Deception and illegal working offences under UK immigration law. Immigration Act 1971 outlines rules and regulations governing the entry, stay, and deportation of non-British citizens in the United Kingdom. Part 1. Regulation of entry and stay in the UK. General Principles establishes that only individuals with a right of abode can enter and leave the UK freely. Others require permission and are subject to regulation and control. Statement of right of abode details the rights of persons with a right of abode, including exemption from immigration control. General provisions for regulation and control introduces controls for non-British citizens, establishing conditions and restrictions for work, study, and visiting the UK. Section 3(5), Deportation. Non-British citizens may face deportation if the Secretary of State deems it in the public interest. Section 3(6), Further deportation grounds, especially for criminal offences punishable by imprisonment. Section 3(c), Continuation of leave. Leave is extended if an application for leave variation is pending. Deportation procedures, deportation orders and grounds for appeal. Certain exemptions for long-term residents. Part 3, Criminal Proceedings. Section 24, Illegal entry and offences covers penalties for illegal entry or remaining beyond allowed time, false representation, and deception for immigration purposes. Section 24A, Deception, offences involving false statements or deceptive actions. Section 24B, Illegal working, criminal penalties for working illegally. Section 25, Assisting in unlawful immigration, penalties for assisting illegal immigration into the UK or an EU state. Additional offences related to non-compliance with reporting requirements, medical checks, and embarkation restrictions. Key administrative provisions. Schedule 2 Administrative controls on entry, reporting obligations, and detention authority for certain immigration officials. General provisions. Individuals subject to immigration control must comply with specific administrative requirements. Arrival and departure regulations. Specific guidelines apply for arrivals from common travel areas like Ireland and Channel Islands. Certainly. Here's the content with bullet points removed and keywords highlighted for emphasis. 24A. Deception 1. A person who is not a British citizen is guilty of an offence if, by means which include deception by him, a. he obtains or seeks to obtain (I) leave to enter or remain in the United Kingdom, or 2. an ETA, or b. he secures or seeks to secure the avoidance, postponement, or revocation of enforcement action against him. 2. Enforcement action, in relation to a person, means, a. the giving of directions for his removal from the United Kingdom, directions, under Schedule 2 to this Act or Section 10 of the Immigration and Asylum Act 1999, b. the making of a deportation order against him under Section 5 of this Act, or c. his removal from the United Kingdom in consequence of directions or a deportation order. 3. A person guilty of an offence under this section is liable, a. on summary conviction, to imprisonment for a term not exceeding 6 months or to a fine not exceeding the statutory maximum, or to both, or b. on conviction on indictment, to imprisonment for a term not exceeding 2 years or to a fine, or to both. 24B. Illegal working 1. A person, p. who is subject to immigration control commits an offence if, a. P works at a time when P is disqualified from working by reason of P's immigration status, and b. at that time P knows or has reasonable cause to believe that P is disqualified from working by reason of P's immigration status. 2. For the purposes of subsection 1, a person is disqualified from working by reason of the person's immigration status if, a. the person has not been granted leave to enter or remain in the United Kingdom, or b. the person's leave to enter or remain in the United Kingdom, I, is invalid, 2. has ceased to have effect, whether by reason of curtailment, revocation, cancellation, passage of time or otherwise, or 3, is subject to a condition preventing the person from doing work of that kind. 3. A person who is guilty of an offence under subsection 1 is liable on summary conviction, a. in England and Wales, to imprisonment for a term not exceeding 51 weeks or a fine, or both, b. in Scotland or Northern Ireland, to imprisonment for a term not exceeding 6 months or a fine not exceeding level 5 on the standard scale, or both. 4. In relation to an offence committed before Section 281(5) of the Criminal Justice Act 2003 comes into force, the reference in subsection 3a to 51 weeks is to be read as a reference to 6 months. 5. If a person is convicted of an offence under subsection 1 in England and Wales, the prosecutor must consider whether to ask the court to commit the person to the Crown Court under Section 70 of the Proceeds of Crime Act 2002, committal with view to confiscation order being considered. 6. If a person is convicted of an offence under subsection 1 in Scotland, the prosecutor must consider whether to ask the court to act under Section 92 of the Proceeds of Crime Act 2002, making of confiscation order. 7. If a person is convicted of an offence under subsection 1 in Northern Ireland, the prosecutor must consider whether to ask the court to commit the person to the Crown Court under Section 218 of the Proceeds of Crime Act 2002, committal with view to confiscation order being considered. 8. The reference in subsection 1 to a person who is subject to immigration control is to a person who under this act requires leave to enter or remain in the United Kingdom. 9. Where a person is on immigration bail within the meaning of Part 1 of Schedule 10 to the Immigration Act 2016, a. the person is to be treated for the purposes of subsection 2, as if the person had been granted leave to enter the United Kingdom, but b. any condition as to the person's work in the United Kingdom to which the person's immigration bail is subject is to be treated for those purposes as a condition of leave. 10. The reference in subsection 1 to a person working is to that person working, a. under a contract of employment, b. under a contract of apprenticeship, c. under a contract personally to do work, d. under or for the purposes of a contract for services, e. for a purpose related to a contract to sell goods, f. as a constable, g. in the course of Crown employment, h. as a relevant member of the House of Commons staff, or I. as a relevant member of the House of Lords staff. 11. In subsection 10, contract to sell goods means a contract by which a person acting in the course of a trade, business, craft or profession transfers or agrees to transfer the property in goods to another person, and for this purpose goods means any tangible movable items. Crown employment, a. in relation to England and Wales and Scotland, has the meaning given by Section 191(3) of the Employment Rights Act 1996, b. in relation to Northern Ireland, has the meaning given by Article 236(3) of the Employment Rights, Northern Ireland, Order 1996, SI 1996-1919, NE 16. Relevant member of the House of Commons staff has the meaning given by Section 195(5) of the Employment Rights Act 1996. Relevant member of the House of Lords staff has the meaning given by Section 194(6) of the Employment Rights Act 1996. 12. Subsection 1 does not apply to a. service as a member of the naval, military or air forces of the Crown, or b. employment by an association established for the purposes of Part 11 of the Reserve Forces Act 1996. 13. In this section, contract means a contract whether express or implied and, if express, whether oral or in writing. Dash.